Welcome back to the Licensing Subcommittee decision, Thursday the 4th of December 2025, in the matter of the Licensing Act 2003, application for a premises licence Southsea Market, 100 Palmerston Road, Southsea. All parties shall receive written notification of this decision. The decision. The subcommittee has considered very carefully the application for a premises licence at premises known as Southsea Market. It gave due regard to the Licensing Act 2003, the licensing objectives, statutory guidance and the adopted statement of licensing policy. The subcommittee considered the relevant representations both written and given at the hearing by all parties. Human rights legislation and the public sector equality duty has been borne in mind whilst making the decision. The application relates to shop premises and is for the provision of retail sale of alcohol off sales. The application was made following the premises licence having lapsed due to a dissolution of the premises licence holder, a company. The application now seeks a new licence to reinstate the premises' previous provision and initially requested to extend the trading hours and the hours for the sale of alcohol from a terminal hour of midnight to 0200 on Friday and Saturdays. It was confirmed at the hearing that the application had been amended to reduce the hours to those previously in place. The hearing was previously adjourned so that the applicant might seek legal advice and arrange an interpreter. The conditions have been proposed and circulated by the applicant in advance of the hearing and were carefully considered. The application has generated representation from the following responsible authorities: Licensing Authority, raising concerns under the grounds of crime and disorder and the protection of children from harm, with concern that if this licence is granted, it would undermine those licensing objectives. Trading Standard adds an additional concern under public safety and has evidence of concerns of how the premises have been operated and the products sold. A conviction of the director of the applicant company for the illegal sale of tobacco is reported to have resulted in a 2-year prison sentence, suspended. Hampshire Constabulary expressed significant concern and provided evidence of the applicant selling alcohol to a child. The subcommittee noted that there had also been one representation from a local councillor regarding the late hour of operation applied for on a Friday and Saturday until 0200, with persons buying alcohol and consuming it in the street in the early hours of the morning, leading to noise and annoyance caused to local residents. The representation, whilst not officially withdrawn, was attributed little weight in light of the amendment of the application to pre-existing hours. Whilst making deliberations, the subcommittee was referred to paragraph 10.15 of the statutory guidance, which indicates that shops, stores and supermarkets should normally be free to provide sales of alcohol for consumption of the sales at any times that the premises are open unless there are good reasons based on the licensing objectives to restrict the hours. After having heard all of the above evidence, the subcommittee determined to refuse the proposed application. Reasons. In summary, the subcommittee heard on behalf of the premises the following points. The application has been amended to reduce the hours. A comprehensive list of proposed conditions had been circulated to address the issues at the premises, including CCTV, refusal logs, challenge 25, training log, delivery from the premises, alcohol strength, till prompt, invoice retention and spirits location. There had been positive improvements at the premises. There had been significant investment at the premises and a 25-year lease. It was not deliberate to continue trading without the licence. It's common to fail to understand the impact of dissolution. There were no objectives to the application for other premises at Albert Road. There may have been a defence to the underage sale of alcohol as a member of SIA door staff had been employed and instructed to check ID. Previous failings to accept, but conditions now seek to implement proper due diligence moving forward. Licensing solutions pack of documents and training by Mr Walsgrove had been put in place. Previous reliance on wholesalers would be addressed by way of condition requiring invoice retention. A member of staff should be trained and undertake the personal licence exam and be appointed the DPS. TILs will have age-related prompts. The business and the applicant's home are in jeopardy as the inability to sell alcohol means the knock-on effect is far greater than the revenue from alcohol sales. This will also lead to loss of jobs for 2 staff. It wasn't accepted that the premises was a target for those seeking to buy alcohol underage. The applicant understands that any future issue will necessarily mean a loss of the licence and a real possibility of loss of the other premises licence. Staff at the premises are now enthused and engaged. The premises did pass test purchases conducted by the police and Trading Standards. The police indicated that the premises had been under the control of the director of the current applicant company since 2021. In that time, the premises premises cause concern in relation to the crime and disorder objective, particularly in relation to the sale of alcohol to those under 18 and the breaching of conditions attached to the licence. It was indicated that there was a common theme relating to the sale of alcohol to children at the premises and the continued illegal sale of alcohol despite the licence having lapsed. Issues of concern relating to the express failure to comply with conditions attached to the licence included multiple and repeated failures to operate CCTV as required, lack of Challenge 25 policy being implemented, refusals registered not being maintained, alcohol displayed in breach of condition RE strength. The police indicate that reports received indicated that under 18s were purchasing alcohol at the premises and were responsible for antisocial behaviour. This led to a test purchase operations. It is also noted that the premises would have been the subject of review proceedings initiated by responsible authorities had there been a valid licence in force at the time. The premises had failed a test purchase and conducted a sale to two 16-year-olds in August 2025. Trading standards set out in detail the concern they hold in relation to the application. Whilst accepting that proposed conditions were a step in the right direction, they were not satisfied that the risks would be addressed and that issues would not be repeated. They outlined that the criminal conviction relating to significant tobacco offences at premises at Albert Road, committed by the director of the applicant in this matter, had not resulted in a change of behaviour. Warnings and formal warnings in relation to the application premises likewise show that there is continued reason for concern and there has been a lack of due diligence that would be expected to address the risk posed to the health of children in the local community. The licensing authority confirmed the conviction, which must be considered significant on the facts and sentence, had not been reported to it. Both the police and trading standards expressed a lack of confidence that the applicant would properly address the licensing objectives in light of the extensive history of engagement. It is clear to the subcommittee that the concerns of the responsible authorities have not been addressed by the detail and nature of this application, and the licence, if granted, would only serve to undermine the licensing objectives. The subcommittee acknowledged the statutory guidance indicates that shops ought to generally be permitted to sell of alcohol during the hours of premises are open unless there is a good reason. In this case, the subcommittee is satisfied that there is a good reason to do so on the basis of the concerns expressed by the licensing authority, the police and trading standards, and the extensive history of non-compliance. The subcommittee noted that the responsible authorities, the police and trading standards, are experts in their respective fields and accordingly attach significant weight to their views based upon the evidence provided, and then that the premises licence application ought not to be granted in order to promote and protect the licensing objectives. The subcommittee noted that the steps outlined by the applicant carefully balanced the interests of the business and the financial impact of the decision against the risks posed to the licensing objectives, but was satisfied that it was appropriate to refuse the application in this case for all of the reasons above. There is right of appeal to all parties to the Magistrate Court, which must be made within 21 days of notification. Thank you, everyone.